All right, your name, sir?
Johnny Luke Dornberry.
All right, so we had that one violation, then she prepared a second violation, and
This hearing starts like a routine probation violation case. But don't let that fool you, because what unfolds here is a perfect example of how quickly someone's second chance can hang by a thread in a courtroom. The man standing before the judge is already carrying multiple technical probation violations, and now he's facing two new allegations tied directly to drugs. On paper, that may sound straightforward, but the stakes are enormous. We're talking about the possibility of probation being revoked, a criminal conviction being entered, and even jail time. What's especially important here is that the judge isn't just looking at one mistake. Courts often examine patterns of behavior. When someone repeatedly violates conditions that were designed to help them stay out of trouble, patience starts running out. And that's exactly the tension building in this courtroom. The defendant is about to admit to both a cocaine-related violation and a new drug paraphernalia conviction. But here's the bigger question. Should a court focus primarily on punishment, or should it give more weight to rehabilitation when someone is actively seeking treatment? As you watch this hearing unfold, pay close attention to the judge's reactions, the defense attorney's arguments, and the defendant's own admissions. Because later in this case, a major detail emerges that completely changes the tone of the hearing and puts the defendant's future in serious jeopardy. By the end, you'll see how a judge balances accountability, public safety, treatment efforts, and repeated violations, all in just a matter of minutes.
how's he going to proceed on this next show cause dated April the 21st?
On the two new charges, Judge.
Correct.
Help him, please.
Is that what you want to do? If you plead guilty here, I want you to understand, since you've already got, it looks like 5 technical violations, that your probation could be revoked, and you could be incarcerated on this charge for the maximum, which is up to 90 days. Do you understand that?
Yes.
And also your 7411 status could be revoked and the conviction entered. Do you understand that?
Yes.
All right. I already covered your rights with you today, but I'll do it again. You have the right to remain silent. You have the right to a hearing. At a hearing, you have the right to question their witnesses, to bring in your own. To use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing of any kind. Do you understand that?
Yes.
It's count 1 that you fail to refrain from consuming alcohol, testing positive for cocaine metabolite on a test of April the 8th of 26. How do you plead? I can't hear you.
Guilty.
Did you in fact consume cocaine, say within the 7 days before that?
Yeah, I was.
Count,
Yeah.
count 2 that you failed to refrain from violating a law, being convicted of drug paraphernalia on April 14 of 26 with an offense date of March 4 of 26. How do you plead? Were you convicted of drug paraphernalia arising out of an offense date that occurred on March 4 of 26?
Yes.
Were you convicted on that case on April 14
Yes.
of 26?
Yes.
And that's after I placed you on probation on this case, true?
Yes.
Anybody force you to plead guilty?
No.
Please accept it.
At this point, the defense is trying to paint a picture that many judges genuinely want to see a person who has started rebuilding their life. We hear about steady employment, a stable place to live, weekly therapy, medication-assisted treatment, and regular attendance at recovery meetings. These are all factors courts typically consider favorably because they suggest someone is making meaningful efforts toward rehabilitation. But there's a legal reality that often gets overlooked. Progress alone doesn't erase violations. A judge can acknowledge positive steps while still deciding that repeated non-compliance outweighs those improvements. That's the difficult balancing act happening right now. The defense is essentially asking the court to focus on where this man is headed, while the probation violations force the judge to focus on where he's been. And here's a question for you. If someone has finally started getting their life together but continues breaking probation rules, should the court prioritize their recent progress or hold them strictly accountable for every violation? Let us know what you think, because that exact debate is about to take center stage.
To those 2 counts, Ms. O'Donnell, your name? Anything you'd like to say?
Judge, just that I know the issue with Mr. Thornsberry is kind of a sensitive issue with regard to how the court's going to proceed on this. Judge, at first, he did have some issues going in, but since then, I think he's made some improvements and he's been able to come to a more stable period in his life, Judge. He is currently working at a company called Dayhot Solutions in Romulus, Judge. He's a highway driver. He's been doing that for the last 2 months. He's making $17 an hour. He currently lives in Flat Rock. He's got his own apartment. He is in therapy at Team Wellness. He goes there once a week for group therapy, Judge. And he just about 4 weeks ago, he was prescribed Suboxone, and that's helped him deal with his urges and has helped get him under control with regard to the issues with the controlled substances, Judge. He tells me that he's doing well on that. He sees a psychiatrist that prescribes him the Suboxone. He does also go to meetings. He goes to NAAA 3 times a week. He's been doing that. Going to Mr. Thornberry since December to January of this year. He is able to pay half the balance that's owed on the probation judge by next week. He's able to pay $100 today towards that balance. And if he does go to jail, Judge, I think this is going to set him back. He's going to lose his job, and I think he's just going to go back to square one. It is kind of a touchy situation with Mr. Thornsberry.
Anything you'd like to say?
I want to apologize to the court. That's all I've done wrong. But if you give me a second chance, I'll make better decisions and better choices.
And there it is, the moment that dramatically shifts the entire hearing. The defendant just asked for another chance, but the judge immediately points to a devastating fact: another positive cocaine test. In courtroom terms, this is the kind of information that can completely undermine an argument for leniency. Why? Because the defense is trying to convince the court that treatment is working and that the defendant is moving in the right direction. A recent positive drug test sends the exact opposite message. Listen closely to the judge's language here. He's no longer talking about a single mistake. He's talking about multiple opportunities, repeated violations, and what appears to be a continuing pattern. Judges often have broad discretion in probation cases, but one thing they consistently look for is evidence that a defendant is taking court orders seriously. The concern now isn't simply drug use. It's whether the defendant can be trusted to comply with conditions going forward. The atmosphere in this courtroom just changed from hopeful to critical, and the defense now faces an uphill battle trying to convince the judge not to pull the plug on probation altogether.
I probably would have given you a second chance if I hadn't been told that you tested positive for cocaine again. Yesterday. Hang on. Let me finish. You were positive April 8th. You got a criminal conviction involving drugs, drug paraphernalia. What can I do? Second chance, you've had 7 or 8 or 9 extra chances. Has he been in intensive outpatient yet?
He had an intake for it yet. I don't believe he started it yet. He is compliant with treatment since he's been in just one-on-one treatment, and he has been prescribed Suboxone since the beginning. I mean, I'm obviously concerned, and you are as well. Again, especially too, he's only 2 clean tests since he last saw you. He tested clean on April 1st, and then he tested clean on April 14th. Those are the only 2 clean tests I've had since the last time he saw you. Obviously, I'm concerned as well as everyone else regarding his use. He's always been honest about it. He's always come to me and told me. I can't fault him for that. He's always honest. But again, I don't know what else we can do for him at this point.
I'm almost ready to revoke probation. That's how close I am. You can't keep using. You can't keep using.
Judge, would the court be willing to take this issue under advisement, considering he just started Suboxone, and since then he's reported positive results at least?
He just tested positive.
And he
Well, he started the Suboxone 4 weeks ago.
Yes, but he tested positive on April 8th, and he was already on Suboxone then too.
And he tested positive yesterday.
No, that hasn't been confirmed as part of my
He
understanding.
didn't have the money to pay for the lab until he was on the admit, so.
And he also does report being drug tested when he does go to the psychiatrist's office as well, Judge, to get that prescription for the Suboxone. He does say that they also test him, and if he comes up dirty, they won't prescribe Suboxone to him.
This is the turning point of the entire case. The judge has reached the conclusion that many defendants fear hearing. Probation is being revoked. The special status is being revoked. And the conviction will officially be entered. What's notable is how direct the judge is here. He specifically says he cannot, in good conscience, do anything else. That wording tells us he believes the evidence has crossed a line where continued leniency is no longer appropriate. Notice something else happening beneath the surface. The defense is emphasizing treatment, recovery efforts, and recent improvements. The judge, meanwhile, is emphasizing accountability and compliance. Neither side is necessarily ignoring the other's concerns. They're simply weighing them differently. That's what makes probation hearings so fascinating. They're often less about whether someone made mistakes and more about whether the court still believes future compliance is realistically possible. So here's another question. If you were the judge, would you have given one final opportunity for treatment, or do repeated violations eventually make revocation unavoidable? The answer isn't always as simple as it sounds.
I cannot in good conscience do anything but revoke his probation, revoke his 7411 status, and enter the conviction. So that's exactly what I'm going to do. Now I'm going to sentence him on the charge, and I'll listen to whatever else you want to say. So I'm revoking that status, the conviction's entered, and now I'm going to sentence him without 7411 status, and I will go ahead and do that now if you're ready to proceed.
I have nothing further. I don't know if Mr. Cronberry has anything else.
There's nothing I can say, you know. I don't understand.
Has he paid anything on this yet, Heather?
On the such he has a balance of 880 still.
No, I even told you, I set you up 75 weekly beginning February 13th, and I told you if you didn't have the money to come talk to me. And you didn't come and talk to me, and you just kind of blew it off. And you haven't made a single payment. And I do that with everybody, and I just don't understand why someone would just blow that off. I mean, it's just hard for me to get. Did he do any of his court work program yet?
He is not.
Didn't let Jessica know that I didn't have the money.
You can't just tell her. I didn't tell you just if you don't have the money, tell the probation officer. Didn't I tell you to come and talk to me? Well, then why'd you tell her? Why don't you tell the guy who sits in right field at the Tiger games? I don't know what to tell you. I just don't understand it. But the money, I want to be clear about this. What I'm going to do now has nothing to do with your failure to pay the money. It's just another example of you being aloof about court orders, but it has nothing to do with you not being able to pay the money. 12 months probation, you cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. No kratom, no poppy seeds and CBD oils. If you consume food or other items containing those substances, it will be deemed a violation. You're to submit to chemical testing, PBTs and ATGs weekly for 4 months, then bi-weekly if you're clean for the duration of probation. 15 days jail, credit 1, serve 14, 3 on the court work program, 11 days now, attend ANA 3 times a week until an intensive outpatient treatment. So basically, I'm going to assess fines. I'm gonna let you pay fines of 100, costs 150, 75 victims' rights, $50 justice assessment, 375, screening fees 60 for 435, probation fees are 240. For 675, court work program fees are 105 for a total of 780. You're to pay 50 weekly starting May the 18th. You may be eligible for early discharge from probation if you're compliant going forward after 6 months. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. This could have been a lot worse. So you have to do 3 days court work. You're in custody for the next 11, 50 a week starting May the 8th. That's where we'll go with this. You just got to pay more attention. Good luck. You have a seat over there. Thank you.
What makes this case so interesting is that the final outcome lands somewhere between mercy and punishment. The defendant admitted to using cocaine, admitted to the probation violations, and faced a judge who openly expressed frustration with repeated failures to comply with court orders. The court ultimately revoked probation status protections and entered the conviction, a significant consequence that will likely follow him long after this hearing ends. Yet despite that, the judge also made it clear that things could have been much worse. Instead of imposing the maximum punishment available, the court structured a sentence that still includes probation, treatment requirements, drug testing, recovery meetings, financial obligations, and a pathway toward early discharge if compliance improves. The larger lesson here is one courts wrestle with every day. Rehabilitation only works when accountability comes with it. The judge acknowledged the defendant's efforts, but ultimately decided that repeated violations required meaningful consequences. In the end, this hearing wasn't just about drug use. It was about trust, responsibility, and whether court orders still matter after multiple chances have already been given. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.